Hello, and welcome to Runkle of the Bailey. My name is Ian Runkle. I'm a Canadian criminal defense and firearms lawyer. Today I'm going to talk about a case that's got me pretty upset, and that's because this is one of those cases where the justice system seems to actually be an engine of injustice rather than what it's supposed to be. In this case, a woman who was the victim of a very serious crime there was a publication ban issued in order to protect her name, and she has been convicted after a guilty plea and sentenced to a fine for violating this. So I'm going to go through this case in some detail. I know it's been reported in the news, but we're going to go directly to the transcript. We're going to go over this in some detail, and I'm going to have some thoughts and some opinions. So let's get started. So this is the case of the Queen and CL. The reason why her name is in initials is because, of course, there's a publication ban. They don't want to just give her name away in something that you can just order up. So that's there to protect her. And this was a proceeding on plea and sentence. This is a guilty plea, and the sentencing was happening right away before the Honorable Justice A. McKay. And counsel on this was B. White for the Crown and B. Russo for CL. So let's have a look at this. I'm going to go through and sort of explain as we go as to what's happening, because there's a lot of stuff here that is very familiar to lawyers, but not super familiar if you haven't been through the system a whole bunch of times. So the court, and could you just cover the elements of the pre-plea inquiry on the record, please? I understand that they've been addressed in the agreed statement of fact as well, but if you could do that before we begin. So what they're talking about here is that the court has to be satisfied about certain things before they accept a guilty plea. One of those is that the accused knows that by entering a guilty plea, they are admitting the essential elements of the offense, and as well as any specific facts that are being alleged, and that in the process, they're giving up their right to have a trial where those things would have to be proved by the Crown beyond a reasonable doubt. The next thing is that they are doing so voluntarily, which means that nobody's forcing them or pressuring them into doing it. So you don't have a family member saying plead guilty or else, or, other members of a criminal organization. Sometimes that happens. So it has to be something that they're choosing to do rather than something they're being pressured into. The accused also has to have some understanding of the consequences of a guilty plea, which can include things like a criminal record, potentially immigration consequences, ancillary orders, that kind of thing. The court expects that to be covered. Also, people need to have it explained to them that even where there's a joint submission, and that's where the Crown and the defense agree on the sentence and present it together as a sort of common position to the court has the authority to reject that joint submission and impose some other sentence, which might be higher if the court thinks the sentence is too low, or it might be lower if they think it's too high. The court can go in either direction in terms of deviating from it. There's a procedure for them to do so, but the court does have that option. So there's a bunch of things that the court wants to make sure have been canvassed before they go ahead. So that's what they're asking here. Ms. Ruoso, that's fine. Ms. L and I have had fulsome discussions about the voluntariness of her plea, which she accepts here today, and although we are requesting a consideration of a joint submission for a sentence, that the final decision is yours, Your Honor. So skipping ahead, Clerk Registrar is now reading the charges. CL, you stand charged that on or about the 19th day of October in the year 2019 at the city of Kitchener in the West Region did, without lawful excuse, disobey the lawful order made by Justice Catch, I think it is, of the Ontario Court of Justice, to wit, a publication ban contrary to Section 127 of the Criminal Code of Canada. To this charge, how do you plead? Guilty or not guilty? And CL enters the plea of guilty. Now, just as a note here, Section 127 is sort of a catch-all section in the Criminal Code for violation of a court order. Now, the way people usually get a charge under Section 127 is often when they violate a peace bond. And a peace bond is a court order that directs people to, usually it's used sort of short of charging somebody with a criminal offense, but to keep two people away from each other who might be fighting or that kind of thing. So having a Section 127 violation on your criminal record is actually kind of a big deal, because most people looking at the criminal record are going to think it's worse than what it is. So this is not something I would want to have on a criminal record lightly, But as a result of this plea, that's going to be going on CL's criminal record. So the court, okay, thank you, Ms. L. I'll ask you to listen again carefully. I know that there's an agreed statement of fact. Mr. White, will you be reading that into the record? Mr. White, I'll be reading that into the record, Your Honor. I'll start at paragraph 5, which is indicated as background. And the court says, go ahead. And then starting at paragraph 5 of the agreed statement of fact, entitled background, the complainant in this matter is Mr. L, or Mr. R.L. The accused and Mr. R.L. were married in, and I'm blanking some details out here again, just to make it a little harder to track down who this is. They separated in year, but reconciled in year, before separating again in year. They're divorced as of year. On August 22nd, 2019, trial proceedings began against Mr. R.L. for the charges of assault and sexual assault. Ms. C.L. was the complainant for that trial matter. Now, I'm just going to stop here and talk about complainant, because we've actually had complainant used twice. Complainant is kind of a word that is usually used in the criminal justice system, where a lot of people would say victim. But the reason why you say complainant is because often somebody hasn't been convicted at any given point. So at that point, you say complainant because you don't want to presume guilt. But complainants aren't necessarily the victim. Complainant is, properly speaking, the person who reported the offense. So in this case, the person who reported the charges against Ms. CL is Mr. RL, who was, we see, at trial for the charges of assault and sexual assault, and Ms. CL was the complainant for that trial matter. She's the person who was the subject of those charges. On August the 22nd, 2019, the Honorable Justice Catch ordered a publication ban for the trial proceedings pursuant to Section 486.4 of the Criminal Code. So let's, I'll continue on and then I'll go over and discuss 486.4. So on September 24th, 2019, Justice Catch found RL guilty of the sexual assault on CL. Ms. CL sought to receive a transcript of Justice Catch's reasons for judgment from the court services. So not only was Mr. RL charged with that, he was ultimately convicted of the offense of sexual assault as against Ms. CL. So she is, properly described here as a victim of the very serious offense. Now let's have a look at 486.4, because I think it's going to be quite illustrative when we're talking about what's going on here. So this is order restricting publication, sexual offenses. Subject to subsection 2, the presiding judge or justice may make an order directing that information that could identify the victim or a witness shall not be published in any document or broadcast and transmit in any way in proceedings in respect of, and there's a whole list of sort of sexual related offenses, or any offense under this act as it read from the time before the day in which the subparagraph came into force, if the conduct alleged would be an offense referred to in that paragraph, if it occurred on or after that day. So this is essentially something to catch old offenses and still say that they can have this applied to. Or two or more offenses being dealt with in the same proceeding, at least one of which is covered by the previous section. Now this is a mandatory order on application if that application is made by the victim, the prosecutor, or any such witness. So that's, we can see that this does not apply to the accused. The accused does not have the power to make this demand and have it be mandatory. The victim or the prosecutor. This is very much a section intended to protect people who are reporting these kinds of offenses from having their name dragged through the mud in public. It's intended as a shield for those people. It's not intended as a shield for the accused. Accused people are normally subject to having their name broadcast. The only reason why we are saying Mr. RL in this case is because they were husband and wife. And so revealing his name ends up revealing her name. But if they were strangers, if there was no connection between them, and so Mr. RL's name would not have any connection to Ms. CL, then his name wouldn't be protected under this. That's the only reason he's caught under this umbrella. So carrying on here. On December the 10th, 2019, Mr. RL was sentenced by Her Honor Justice Catch under the heading Offenses or the Offense, which starts at paragraph 9 of the agreed statement of fact. On December the 20th, 2019, the Waterloo Regional Police were contacted by the complainant, Mr. RL, regarding a court document made public via Facebook Messenger. So he's the one who's upset that this has been shared. I kind of think that maybe he's not the guy to listen to here, but carrying on. Police investigated and found that Ms. JG, a friend of RL, received a Facebook message from an account named Harry Henderson. Now, you might be thinking, why aren't you blocking that out? Well, that name is almost assuredly fake. If you're not old enough to catch it, that's a TV reference. So, attached to the Facebook message was a copy of Justice Catch September 24th, 2019, Reasons for Judgment. There was no text to accompany the message. There was typed content to the message. The Facebook message only contained the attached reasons for judgment. So Mr. RL here is upset because somebody is telling his friends that he's been convicted of a very serious criminal offense. That's why he's upset. And it's not clear who it was. So the document was verified by Court Services Division as being a legitimate copy of Justice Catch's September the 24th, 2019 Reasons for Judgment. CL confirms that she had received a copy of Her Honor's Reasons for Judgment from the Court Services Divisions in the fall of 2019. CL spoke to police with regards to an unrelated matter on January the 9th, 2020. We can already see mistakes happening here. I'm not trying to criticize her, but speaking to the police is rarely a good idea. During her discussion with police, CL admitted to having sent Justice Catch's September 24th, 2019 Reasons for Judgment to some of her friends and family through email. Ms. CL does not know who sent the document via Facebook Messenger. Those are the facts for the purpose of this plea. And then those facts are then admitted by counsel for the defense. And so they present a joint submission for a fine in the amount of $2,000 on this matter. So both Crown and defense are in agreement with this penalty. So we can see, Ms. L was born and raised in blank. She and Mr. L went through a very acrimonious separation. And as you've heard, she was the complainant in the sexual assault trial involving her former spouse, and he has been found guilty of that offense. So she's suffered a lot at this stage. They have 2 children, and primarily the children do reside with her. There are still ongoing family court proceedings that she's trying to deal with Mr. L. And do you think when the court is making court orders in family court that they might look unfavorably on a conviction for violating court orders? I mean, this is not going to help. Admittedly, she's probably got the winning cards in that particular family court proceeding, given his convictions, but this does kind of push on the scale at least a little bit there. If he hadn't been convicted, if for whatever reason, and just because somebody isn't convicted doesn't necessarily mean that they didn't do it. It just means that they haven't been convicted. We have a presumption of innocence, but that doesn't change actual facts. Sometimes people do commit offenses and not get convicted of them. So if he had been acquitted, she'd be the only person coming in with a criminal record. That would not look good in those family court proceedings, right? So I have some concerns about that as well. However, given this guilty plea, Your Honor, Ms. L does not have any prior criminal record. So she has no record before she comes, and now she's got a record for violating a court order, which is a bad thing to have on your record if you're ever needing to go to the court for pretty much anything. It's not the worst thing, of course. I mean, there's much worse things, but this is still not great. So she comes before this court accepting responsibility for this matter and acknowledges that she sent the decision basically to her support persons, if I can put it that way, as opposed to doing anything otherwise in respect to this matter. So she suffered a traumatic experience and she's looking for help and support from her, her close community of friends and family, and she's sharing what's going on. I I mean, that kind of sounds therapeutic. It kind of sounds like... So, but it's a violation of the order. So they do some inquiry as to whether or not she can pay the fine, and then they go to the Crown. Crown says, just briefly, Your Honor, so clearly court orders need to be enforced, and there needs to be a clear message to others that court orders are to be respected. Really? Is that the most important message you can get out of this? I think that, I mean, it is important that court orders be followed. Court orders are essential. They're important. People should be following court orders, even if you don't agree with them. But we also need to maybe stop and have some consideration as to whether that's the highest good, and whether or not there might be other competing principles, and whether maybe you should or could let something slide, say, because there's some higher principle here. Like, maybe you don't want to kick the victim of a sexual assault when she's relying on her friends for support. I kind of feel like this message could have been sent just by having a talking to with her, and just by sort of sitting her down and re-emphasizing this point. There has been some discussion of legislative reform to change these publication bans to allow for the complainants to violate them or to have them struck down. Because right now, the complainant, we sort of think of the wording there, the prosecutor can ask for that publication ban even if the complainant doesn't want it. And there's not really a good way for the complainant to get that removed. They're stuck with it, even if they don't want it, even if this is muzzling them when they want to talk. So I think that's a bit of a problem. This is an area that is probably ripe for some judicial reform in order to allow, victims of offenses to speak clearly, or just to say, listen, how about we don't prosecute the victims of offenses for violating the publication bans that are there to protect them. So the Crown continues on, I can advise that the context of this is important. Well, I agree with that. It is real important. Ms. CL was, of course, the complainant in the sexual assault trial. Arguably, the publication ban is there to protect her interests and the interests of her children. I don't think there's much arguably there. That's just straight up what it's there for. The facts of this case relate to her sending that to friends and family, so that context cannot be ignored. Also, I can advise that once I was assigned, because it required an out-of-town Crown, I had conversations with Ms. Russo on this matter, and it was clear at the beginning this was going to be a plea. So the reason why there's an out-of-town Crown is because the Crown would have been prosecuting the underlying sexual assault trial, and so they need an out-of-town Crown to avoid a conflict of interest on this. That's why they're bringing in somebody who doesn't live in the area, who doesn't have any connections to the local Crown or to this the underlying case. And why they're saying it was clear at the beginning this was going to be a plea is that sort of indicates an acceptance of responsibility and reduces the sentence that you can expect somebody to get. It's just been delayed as a result of pandemic concerns and other issues. But at the forefront, it was always going to be a plea to this matter at an early stage once we could get it scheduled. As a result of that, I'm asking again for the joint position of a $2,000 fine, subject to any questions you might have. That seems like a fair chunk of money, right? I mean, $2,000, I can think of things I would rather spend $2,000 on. So the court, no, thank you, Mr. White. Ms. L, you're not required to say anything, but if you would like to, this is your chance. Do you want to add anything to what's been said? Ms. L says, no, sir. No, Your Honor, I have nothing to say. The court is required to give the accused the opportunity to speak up. It is usually a mistake, but if you are ever in this position, talk to your lawyer. Your lawyer will tell you what they think you should do. It's probably going to be to just let the lawyer do the talking because they've probably done a few of those before, but talk to your lawyer because they'll know the specifics of your unique circumstances. So reasons for sentence. So now this is the justice giving their decision. Keep in mind, the justice does not have to accept a joint submission. They can say, I don't think this is appropriate. I don't think this is fair. I'm going to throw this out. Let's see if that's what they do. Well, Ms. L, it is an unusual backstory, your set of circumstances to a charge, including a charge like this. So I understand sort of the emotional impact being a victim of a crime. I'm not going to get into what this justice does or doesn't understand, but I think it would be very difficult to put yourself into those shoes if you're not in them. So I think that's a phrase that we should be really cautious about in circumstances like this. Real cautious. I'm just going to stop there. I know that a crime such as this, it is particularly personal and people have a reaction to that. You don't say. Those reactions tend to be real, this is a real traumatic thing. This is not something, it's being a little undersold here. We'll go with that. So that being said, court orders have to be followed, particularly ones that deal with people's privacy. Again, I kind of feel like there's maybe a higher order consideration here, especially given that the ones that deal with people's privacy is the people that you are sentencing. It's not like some random third party. It's not like... So, yeah. So I'm satisfied that counsel have reached an appropriate resolution, which shows the importance of court orders being followed, but recognizes your personal circumstances as well. So I accept the joint submission. I will impose a fine of $2,000, and this is where the real kick in the teeth comes in. Just the real, we're going to drop a cherry right on top of this sundae. There's also a victim fine surcharge involved. So the victim fine surcharge, if you're not familiar with the criminal justice system, is put in place to fund certain victim services. It is there to compensate victims of crime, and it basically is an additional penalty on top of any fine imposed. That's another 30%. So $2,600. It's a real kick in the teeth here where we're talking about the victim of an incredibly serious and incredibly personally damaging crime and going, oh yeah, and you're going to pay the victim fine surcharge. Ooh, I mean, I get that the law, says that's a thing here, but oh man, that's one of those moments where I'm just like, I've got serious problems with what's going on. So there's some discussion of time to pay. I'm not going to really go into what time to pay involves here, and then they wrap things up. So I kind of feel like a whole lot of people in this story should maybe have stopped and said, are we doing the right thing here? This is one of those situations where everybody sort of seems to be participating in an injustice without stopping to say, am I a cog in a little, in an engine that is doing bad things here? Can we maybe stop this? Can we maybe say, I don't think this should happen? And, the Crown here has tremendous power to, say there's no public interest in this. I'm going to kill these charges. The Crown could have made this go away. The Justice also has a lot of power. They could say, listen, I don't think this is an appropriate penalty. I'm going to impose something less. I kind of feel, now I haven't read the full agreed statement of facts here. I haven't got the full details, but I kind of feel that the appropriate penalty here is probably in the realm of an absolute discharge. And what an absolute discharge is yes, you did it, but no, we're not convicting you. We are, instead of convicting you, entering a discharge into the record. And an absolute discharge is just, there is no punishment, and it's not a criminal record. You don't sustain, so it doesn't go on your record. If you are then having future impacts with the law, it doesn't affect you. So that to me seems like it's an available option for the justice, and I kind of wonder why it wasn't considered here. Are there some details that we're not getting? Defense counsel, I can't comment too much on, simply because defense are the people with the least power in the court system. Because ultimately, defense counsel have to take instructions from their clients, and sometimes that's even where you don't like the instructions. So if your client says, take the joint submission, you're stuck taking that joint submission even if you don't like it. I don't know what discussions took place between counsel and client. That's not something, I haven't reached out to this lawyer to ask that question, because of course that lawyer would tell me the entirely appropriate answer of, go F yourself. That is not a question I'm going to answer, and that is not a question that's appropriate for you to ask. So that's something we'll never know. So I can't really comment too much on the role of defense counsel here, simply because, as mentioned, they're the people with the least power, and I just don't know what all is going on here. Anyway, yeah, this one is real frustrating. I don't think that the criminal justice system should be being used in this way. I don't think that the criminal justice system, when we start thinking of whose side do we want to be on, it looks like they picked team Mr. RL instead of Ms. CL. And when we look at what Mr. RL has been convicted on in this stuff, I'm going, why would that be the team you want to pick? Is that really where you want to hoist your flag? Maybe I'm thinking that Ms. CL is the person who deserves some protection here. And when we're trying to pick a side, maybe that's where we should be trying to land. So, yeah, this is very frustrating. It was frustrating for me to hear about in the news. And when I saw it in the news, I was like, maybe something else is going on here. Let's get the transcript. The transcript doesn't make it any better. This one just has me upset. I know I said I wasn't going to judge defense counsel too harshly, because sometimes you get bad instructions, and so long as those instructions are lawful, you have to follow them because it's the client's decision, because it's their life. But the more I think about it, I have problems with this. I can see a client saying, you know what, I want to plead this out. I just want it to be over and done with. I want it to be gone. But I can't really imagine the circumstance where they're saying, I really want a criminal record, or even I'm okay with a criminal record on this one. And, I really want to pay a substantial fine. The defense submissions on this are fairly brief. I guess they'd be about 2 to 5 minutes, maybe less than. And if there was ever a time to pound the table and to fight for a better result, this is the time. Like, come on. This is one of those circumstances where you'll want to point out, this is an injustice. This is wrong. This is not just that this particular person deserves a break because they've had tough life circumstances, because of, this is outright, we are causing harm. We are putting damage out into the universe. And we are making the world a worse place by this result. And I think that there's a time to sort of maybe even embarrass the people and say, listen, are you okay with what's happening here? Is this something that you are fine with? This transcript has everybody's names on the cover of it. Are you guys okay with your name being on this particular result? Is this something that you are fine with, or maybe should this be something that you view as an embarrassment? Maybe, I don't know. I haven't seen the disclosure. Maybe there's something really shocking in there that, that says that this person deserves a harsh punishment, but I'm trying to imagine what it is, and it's just not coming to me. This one, I wonder if this is not a case for somebody with maybe clearer eyes, maybe the benefit of hindsight, to appeal this joint submission and, come to a consent agreement for just, maybe we'll do something else, like not a criminal record here. I just don't know. Like, this cries out, fix it. This is broken. This is a sore on the face of the universe, and we should fix it. It angers me. This really upsets me in ways that I just can't express, because this is not why I got into law. I did not get into law to see this kind of thing. So, yeah, this is incredibly frustrating, and I want the justice system to do better. That's really what it comes down to. I want the justice system to do better, and I want to feel like the justice system is on the side of victims and not on the side of convicted sex offenders. I kind of feel like when the guy who's just been convicted of a sexual assault calls the police to say, I'm real upset because the victim of my sex assault is getting comfort and help from their friends and family. This is not a time for Commissioner Gordon to pick up the red bat phone and call Batman and get him sliding down the pole off to deal with this one. Maybe it's more time to just call the person up and say, hey, just so you know, your behavior did violate a court order and you shouldn't do that, but we're not going to come after you. Maybe that's a time for, the vaunted police discretion that we hear so much about. And, the discretion not to lay charges. Is this not the perfect example of a case where discretion not to lay charges is really called for? I'm struggling to think of a better one. So thank you for watching. If you've, I want to say enjoyed, but enjoyed is the wrong word. If this has been helpful to you in terms of your own education, please like this video, please share it with your friends, subscribe to see more content. I also want to thank my Patreon supporters at the $50 level: Sir Daniel Wicks of Alberta, Jason Elliott, Canada's National Firearms Association, North Central Process Service, Kyle Martin, Jean-Guy Toussaint, and the Canadian Shooting Sports Association. At the $30 level, Sights and Arms Limited, and at the $20 level, Dale Nesbitt, Cameron Johnson, and Andrew Elsich. I also want to thank all of my $10 Patreon supporters who will be in the crawl immediately following. Thank you for watching, and I hope this is armed you with knowledge.